second one of it. So in those circumstances where you've exhausted your merits review options and you need to seek, or a litigant wishes to seek judicial review, if it's the ultimate outcome which is their concern, then often though they will try and rely on Wensbury unreasonableness by contending that because they don't agree with the decision or decisions which are under review, that it is therefore wrong. And so courts, understanding that there's already been a process of merits review in place and that their only role is to supervise the procedure of the decision-making process and the legality or lawfulness of that, will be inclined as a starting point not to intrude into those processes which are established by statutory law and which should be deferred to in the case of the outcome or the correctness of the decision that's been reached. So that's the starting point, where Wensbury unreasonableness, because of that public policy ground, because there are other mechanisms that should operate, and if there aren't those other mechanisms that operate, that's within the prerogative of the legislature not to provide such processes, will be wary that a person seeking Wensbury unreasonableness is trying to circumvent that other public policy, which is that merits review should be limited to those forums for which the legislature has provided, and that judicial review cannot be used as a backdoor. Now, that was your first point, I think, Ray. Your second point, I think, of the two that you made, was in what circumstances would it be successful? Now, that's the million-dollar question. You could put 10 lawyers, 10 experienced administrative lawyers in a room and ask that same question and get 10 very different answers, or at least 10 varying answers. The easiest way for me to answer the question for the level of understanding you need to have is that keep in mind perhaps those established categories of cases, and they're set out in the notes, for example, where there's an entire lack of plausible justification for the decision that has been reached. That's one category of case. Now that won't always be easy to establish because it's a factual consideration, and for those of you who have read the notes, you'll be aware that the decision of Director of Animal and Plant Quarantine, I think it is, in Australian Port, explained one of the I think there were 3 judges, and I think the joint judgment makes reference to, and this has been extracted into the notes, the fact that where fact-finding is being challenged, then it will be more difficult to succeed on a ground of Wensbury unreasonableness. And that's because, again, as a matter of public policy, appeal courts, including courts exercising judicial review, are reticent to re-find facts. So in a strict appeal, so not merits review or judicial review, in a strict legal appeal, the starting point tends to be that you cannot appeal the finding of facts, that the finding of the facts is a matter for the first instance judge or tribunal, and that subsequent appellate or review courts should not seek to re-decide those facts. Now, in modern strict appeals, that tends to be the case, although the ultimate appellate courts tend to have a power to remake. That is the ultimate state-based intermediate appellate court, so the Court of Appeal of each state. The laws that create those courts, or that establish them as a division of the Supreme Courts, make provision for them to be able to re-find facts. But they do that sparingly, and they do that so that, again, as a matter of public policy, you can imagine that if every litigant in a case who was dissatisfied with the outcome, and that tends to be 50% of all litigants, because for the most part, assuming that you've got two parties, one's going to win and one's going to lose, and you could imagine that if every time somebody lost, they could simply run off to an appellate court and ask for a redetermination, the courts would ground to a halt. They just wouldn't have the resources to hear these cases. So keep that in mind whenever you've got a case involving a fact finding, and you tend to have them. The other category, and again this is dealt with in the notes, is where there's something about the decision which is capricious or oppressive. That is, sometimes you'll find, and you find this particularly I think in everyday life when you're not dealing with trained decision makers, so I'll just interpolate there. One of the reasons that you do legal training is hopefully so that you're learning the discipline, not only of the practice of law, but also in critical analysis and thinking. And so one of the reasons that, or one of the justifications for typically giving lawyers, in 99% of cases, the powers to make decisions which affect people, whether it be in a tribunal, or it be in a court, or whether it be a special or standing commission of inquiry, such as the Crime and Misconduct Commissions or Royal Commissions, etc., is that by virtue of the training, they're supposed to have a discipline, a mindset that allows them to professionally consider facts and adjudicate on them. And that is in contrast often to how we behave in everyday life. So sometimes, for example, if somebody misleads us or lies to us, we'll just conclude that they're a liar and that they can't be trusted, and so nothing they say is worth anything, and we move on. In a legal setting, what you tend to find is lawyers, the judges and tribunal members, hopefully, in particular the better ones, not all of them, they sit back and they say, okay, well, why did the person lie? There can be many different reasons for the lie. They might have been embarrassed, they might have been genuinely mistaken, they might be trying to perpetrate a fraud on the court. So they cast a number of potential explanations, and then they examine each of those explanations to decide which one best sits with the facts. Now, capricious use of power could apply, for example, where somebody has been mistaken about a matter before the tribunal, and that as a result of that mistake, the tribunal comes to a conclusion that they're a liar, therefore their case has got no merits, even though it might be the case that all of the objective evidence supports them. And this is particularly important. I see it quite often, for example, in refugee cases, where you'll have an officer of the Department of Immigration and Citizenship appointed by the Minister to examine a claim for asylum. And what they will do, and mind you, it's not limited to these people. I unfortunately all too often see it in inferior courts. Bad decision makers, they go through and they try to cross-examine on, and so do advocates for that matter, cross-examine on peripheral issues which really aren't significant and which aren't in the forefront of a party or a witness's mind, and they try to lull them into traps and tricks and sort of paint them as a liar when really it's not relevant to the crucial matters. And so if you saw that sort of thing going on, not always, but that might be an example of where capricious use of power might arise as a basis for appeal. The case that you would need to be familiar with, hopefully you've read it, and if you haven't, it's in the notes and also in the case book. of Edelson-Wilcox. That's one where the federal court considered capricious use of power, and that would be the sort of case you'd be expected to refer to in the exam. You've then got, for example, other categories such as unjustified unequal treatment. So, for example, if you had a number of, let's say you had 6 cases, the first 5 had, or all 6 of them had very similar facts. The first 5 are all decided a certain way, and the 6th case is decided differently. You might contemplate the reasons why it would be decided differently, and whether or not there was some justification for that. If there wasn't, then what you might find is a court exercising the power of judicial review, setting aside the decision, and that, for example, might be seen in licensing cases. In fact, I think, let me just put the notes. I think in the notes there's reference to a licensing decision. Anyone know which one I'm talking about off the top of the head?
Case.
Sunshine. Sorry?
Sunshine Coast Broadcasters.
That's the one. Yeah, Sunshine Coast Broadcasters is your example there. Now they're the common law grounds that we've touched upon. You've got, you can see there on the notes after Sunshine Coast Broadcasters is dealt with, you've got the Administrative Decisions Judicial Review Act grounds of fraud and bad faith. And surprise, surprise, we've got immigration decisions popping up again, being considered by the federal court, the full federal court. Ray, is that a really long answer to your question? Have I answered it in your mind?
Yes, that's fine. Thanks.
One thing, where if Wednesbury unreasonableness appears to pop up in the exam, and you should expect that probably it will be a matter to mention for 1 or 2 questions. There's 3 questions in the exam you've got to answer to. There'll be 2 problem questions and 1 essay type question. In the problem questions, you should assume that, you know, Wednesbury unreasonableness along with other common law grounds is going to be a matter to allude to and or make reference to and discuss depending on the facts as you see them and its applicability. You do want to go through if you are dealing with Wednesbury unreasonableness, you do want to be able to cite the nature of the ground. So what generally are the circumstances where it will apply. You'll want to be able to cite the case, not the full citation, but at least the name of the case from where it gets its name. You want to be able to make reference to the fact that as a starting point, courts are not warm or don't warm to it as a appeal ground. And you want to be able to, if it applies, place it into one of the established categories. And the established categories are not exhaustive. So the ones that we've just been talking about are not, it might be that Wednesbury unreasonableness would apply even though it doesn't fit in very neatly to one of the established categories. Those categories are really just shorthand so that you've got sort of a reference point. You can, if you've learned those categories and you look at a particular problem question, you're able to say, okay, that sounds like it might be this particular category, and then you've got in your head what the cases are that apply to that category and what the principles are that might enliven it. So that's the sort of process that you would want to be able to follow through in preparation for, in the exam. Any other questions on that? No? Okay, what about Peter Ritchie's question? Which is more common, judicial review for Wednesbury unreasonableness or using the ADJR Act Section 5? What does everybody say about that? Sounds like there's a lot of I'm not quite sure's. If everybody's read the notes, there's something that hopefully is striking about the difference between the Wednesbury unreasonableness type grounds, which are provided for in Section 5, and those which are perhaps within the categories of Wednesbury unreasonableness at common law. What do you think about the applicability of the two different options in those circumstances? I think Ray's observation that common law is more broad is a good starting point. It's helpful. Let's assume that you've got a problem question. Let's assume that you're doing an exam question, and that any of you who have looked at past papers will have seen that often how exam questions for administrative law are framed are to say, here's your set of facts, what sort of judicial review options do you have available? Might be Part 1, Part B might be, if there's a provision in the Act that says that the Administrative Decisions Judicial Review Act applies, how would that change anything? Here is a good example of where you would be able to get points in being able to draw a distinction between the common law and the statutory law grounds, which affects trying to review an unreasonable decision. How would you guys go about it? Don't be shy, speak up. This is your opportunity to have dry runs at the exam. Fraud and bad faith are in addition to the common law grounds, and all of the provisions in the ADJR Act sit alongside the common law, so they're in addition to the common law. When you look at the categories of Wednesbury unreasonableness, or the established categories of Wednesbury unreasonableness at common law, and you compare them to the grounds provided for in the ADJR Act, which provides a more adaptable set of tools. Okay, so we seem to be generally in agreement that the common law is the more adaptable, that's an important starting point, but assuming you've got a 25 mark question, you've probably only just scored half a mark with making that sort of observation. Now what we need to do is go beyond that and explain how, at a practical level, that might impact on how you go about giving advice. So your starting point will be you've got more adaptable grounds at common law, and the reason for that is that the ADJR Act provides either fraud, which is not easy to establish. Fraud requires deliberate or intentional dishonesty on the part of a person, and in this particular context, what you're talking about is trying to establish that a public official, a decision maker, has acted with fraud. Inherently and probably notoriously difficult thing to establish. Your other but somewhat lesser option is to establish exercise of discretionary power in bad faith, but there firstly you've got to establish discretionary power, and then secondly, whilst bad faith is a much lesser standard to meet than fraud, it's still not going to be a simple process. Courts, whether they're exercising power of judicial review or any other power of review, tend to prefer explanations which don't require them to make findings of some degree of malevolence on the part of some other person. And so to that extent, the common law tools might be considered to be more desirable, but that's really just at a sort of practice level. It's not a matter of law. What you're looking to do in circumstances where Wednesbury unreasonableness is a ground that you're suggesting might arise on facts, and where you're trying to explain how the application of the ADJR Act shifts the task or changes the nature of the reasonable prospects of the case, is to show how the common law grounds are, by reason of the principles which are discussed, in particular, for example, in S20, which I hope you've all read, that it is more variable, or unreasonableness is a broader concept, as Ray puts it. Jessica notes that unreasonableness has been used somewhat interchangeably with illogicality and irrationality. That is certainly true, and the courts, for example, in S20, and some of the cases also that we discussed last week, are grappling with how those terms sit together to provide a cohesive explanation for unreasonable decision making. To go back to Ray's question about how you might go about establishing it, reading some of the debate or analysis in the cases, the primary case, the principal cases that we have mentioned this week and last week, should assist you to do that, because what you see is the court toing and froing about what sort of things need to apply in order for unreasonableness to be to have reasonable prospects of success on a judicial review application. Murray says, would the court look at the common law in interpreting Section 5 of the ADJR Act? That's a good question. you actually find analysis in some of the cases along those lines about where it applies, but the ADJR Act provisions, as I've just said, are quite different to the common law. They are very much more closed off in their applicability, in my view, and are not nearly as broad. They're specific. So we might, when we go through the problem questions, I might try and throw in a few additional assumptions or facts for you to hopefully get us a sense of what a case which you could rely on section 51G and E, it is, of the ADJR Act in order to have some real prospect of challenging it on unreasonableness. Sorry, 51G and 51D, for 52D. Other questions before we go to the problem questions? Kylie asked, should you approach exam questions with a set structure or formula? The exam questions have been written. It should be, unless you do the problem question, as I said, the exam will be a choice. You've got to do 2 out of 3. You have a choice of which 2 you do. There'll be 2 problem questions and there'll be 1 essay style question. The problem questions will be quite self-explanatory in the sense of what it is that you're being asked to do and how to methodically structure it. As concerns the essay question, it'll be fairly standard as in any essay question. You'll state your hypothesis and you'll move through your argument to your conclusion. Anyone else? I'm marking your assignments at the moment. They'll hopefully be released to you next week. Anyone else got a question on this week's topic? Sounds like no one has any other questions. You want to go to the problem questions? All right, well, let's go to problem 27. Who wants to lead us off with their views on problem 27? I hope that silence means you're all reading it. It's not a particularly difficult question for somebody to lead off discussion on. You're not going to get as much out of these sessions if you're just listening to me talk through it. This needs to be a dialogue, folks.
I don't like his chances, Brett.
You don't like whose chances? Mr. James?
Mr. James's chances.
Yeah, okay, why not? what is it about this particular problem question that gives you pause when it comes to his prospects of successful challenge?
I think Wensbury unreasonableness needs to be proved something completely beyond reasonableness, and I don't see anything here that would meet that criteria.
Okay. Who else? Who we go? Got
perhaps, sorry, Paul here. Unjustified and unequal treatment. It seems that, I mean, this would be a case where this may have happened before. It would seem to be unreasonable without reference to other former cases. That he just like he's been singled out.
Yeah.
The fact that he's, I mean, the fact that he's got a good standing apart from this dilemma, and it's like the maximum penalty is being applied in a situation that may not require that.
Mm-hmm. So there's potentially two aspects to this particular case which could be subject of challenge, aren't there? What are the two aspects? And this is true really of any legal problem you get. There tend to be two aspects to sort of two general aspects of the nature of the cases are ultimately how the outcome is reached. What's the first component or the first stage? It's what you challenge if you take up merits review.
Would that be the decision's correctness or desirability?
So it's that's probably, depending on how you look at it, Ray, the second stage, which I'm coming to. The first stage I'm trying to allude to is, as Jessica and Kylie have identified, is the fact-finding aspect to it. So the fact that he actually committed the sexual harassment. The second part then is what, Ray? And I think, Paul, you were sort of alluding to this aspect as well.
The severity of the action by the department in handing out the punishment or whatever.
That's right. So it's after you find the facts, you then got to decide what action you take on the basis of those facts. And I think, forgive me if I've misunderstood Ray, but I think what Ray and Paul are alluding to is after you've found the facts, what you do with them. So what is the remedy? Now here, you've got the investigative panel finding that the sexual harassment took place, and then what you've got is them deciding that the remedy is to terminate Mr. James' employment. Now, I separate those in my mind, and I encourage you guys to do it as well, just for clarity of thought, because challenging those two aspects might be very different tasks. Now, this follows on from problem 26, which we did last week, and let's focus for a minute on using the same facts. Let's assume that it's his word against her word. There's a number of people standing outside the room at the time that the conduct was alleged to have taken place, that he has a good history of a good clean employment history, so no conduct like this before. I think most people in those circumstances, most sensible people in those circumstances, not those of us who tend to be inclined to run off at a whim, such that every allegation must be true because it would not have been made if it wasn't true, a obvious nonsense and fiction to anybody who spends any amount of time involved in dispute resolution, which I imagine some of you may be inclined to pursue as a future career. Notwithstanding that, if you don't just run off and conclude that because the allegations made it's true, that what you then have is a body of evidence. You've got one person saying it happened, one person saying it didn't happen, three people saying they didn't hear anything consistent with it happening but can't say one way or the other, and this objective aspect, this character aspect, and how we use character evidence in the law is two ways. We say, firstly, a person of good character tends not to commit crimes, so we use it to weigh the objective likelihood or the probabilities that they would actually do what is alleged against them. And the second part of it is to weigh it in on credit. So we say that people who don't run around committing crimes tend to be good people, they tend to be people you can believe. So what we've got there is, in my view, such a body of evidence that a rational decision maker would conclude that the case can't be substantiated against Mr. James. Now, that of course doesn't change the fact, as we were talking about at the outset of this tutorial, that judicial review, even relying on Wednesbury unreasonableness, is not an opportunity simply for de facto merits review. It's not an opportunity simply to go to the reviewing court and say, here is a body of evidence. The strongest conclusions available on this body of evidence are that Mr. James didn't do it, yet the tribunal has found that he did do it. Would that enliven, if they were your facts and this was your exam question, what would you be saying about Wednesbury unreasonableness? So a good answer, and before I get you to go into the points you'll each need to make, a good answer will start by pointing out that if you're in a judicial review forum, then you've got those grounds available at common law and the ADJR Act. You've got common law grounds or established categories. Under the ADJR Act, you've got explicit categories. At that point, you might say, on these facts, there's no suggestion that the decision maker was or one of the parties were involved in a fraud. That just simply couldn't be argued, nor could it be argued that there was bad faith. That might change. For example, let's assume for a minute that there's a 3-member investigative panel, and 2 of the members of the panel turn out to be on Jill's volleyball team, and that wasn't displayed, that wasn't revealed to Mr. James when the investigation was underway. You might say, well, that's a grounds for bad faith. You might also, for example, interpolate at that point that you might have ostensible bias, by the fact that this is a government department, so ostensible bias is sufficient. You don't need actual bias. And then you might go on to say, now, then you would go on to discuss whether or not Wensbury unreasonableness would actually apply. Now, what's the magic expression that you'd be looking for, that you'd be looking to put down if you were going to talk about the applicability of Wensbury unreasonableness?
Brett, that would be a decision that no reasonable person could have come to.
That's right, something along those lines. To use the expression, and this is where you get maximum points, when you can actually point to the correct phraseology, because this is the study and practice of law is one that depends on very significantly the use, sometimes even manipulation of language, and so small variations in language can matter. That the expression that you find in associated provincial picture houses is so absurd that no sensible person or agency could arrive at that decision. Or you also get obviously points for expressions along those lines, but it's always a good thing to commit the correct decisions to, the correct and accurate phraseology to memory. So that's you'd be raising Wensbury, the Wensbury decision. What Australian decision might we be looking for? And this picks up, for example, on something that, who was it? Jessica, you said, you made reference to
irrationality and illogicality.
Yeah, that's right. So we'd be looking for, and what's the decision? What's the decision you'd be looking to cite there?
You could cite the Minister for Immigration and Citizenship versus the NSZMDS,
Exactly.
where the
And where
it
what
was that.
Yeah.
You could just probably, like I said, refer to the wording where illogicality or rationality is one at which, it's one at which no rational or logical decision maker could arrive at the same evidence.
Right. So you'd be looking to cite the decision, the joint reasons of Justice Crennan and Justice Bell in that decision, which was that a decision might be said to be so illogical or so irrational that that only one conclusion is open on the evidence and the decision maker did not come to that conclusion, or if the decision to which the decision maker came was simply not open on the evidence. So that's an important, that Australian decision is important because that's where the discussion around whether or not serious irrationality or illogicality might be sufficient to enliven an unreasonableness type ground. And it's important in the context of the evolving facts that you see in problems 26 and 27 because of what I was discussing before. You may be able to find a judge, and I would have to say if I were that judge, I might find a certain allure or appeal in a submission that this particular decision was, that is the decision that he actually engaged in sexual harassment, was tainted by illogicality, unreasonableness, if it were emphasised that the only thing which lent itself to substantiating or sustaining the allegation was the person who made it. If denied by a person who is of good character and therefore should be, as a starting point, believed, and from whom it should be considered to be out of character and therefore perhaps more improbable than probable that he actually engaged in the behaviour. 3 witnesses who, if something had happened, you would expect to have seen or heard something consistent with it, who don't go that far and simply say, I had no reason, although they were standing outside the room, to even believe, or even to suspect, sorry, that something had gone on. So you might be able to find a judge who, looking at that factual matrix, finds it appealing that that expression that was used in SZMDS, that the decision was so illogical or irrational that only one decision was open on the evidence, and that decision was that he didn't do it, or that it can't be substantiated. So it's through that building on Wensbury unreasonableness through the Wensbury Corporation decision to the SZMDS decision that you start to get closer and closer to being able to argue that there should be, or that there is, a remedy. Does everybody see where I'm going with that so far? In an exam type situation, you're not going to be marked so much on whether you say yes or no to whether or not Wensbury unreasonableness would apply, so much as you're going to be marked on how you argue that it could or could not apply. And that's the nature of the business, in fact, is that we're, as advocates in particular, marked on how we argue the case rather than what we, whether we win or lose, because every client has a different position, and those cases which can involve a shifting of the judicial officer's mind tend to be few and far between. Paul, I think your microphone has come on accidentally. And that's the same approach that we take to the marking of exams. Is there'll be some questions where if you argue the yes proposition when it was obviously the no proposition, you're going to have difficulty getting marks or full marks. But where if you argue the right cases and you argue convincingly the merits of those cases and the ratio of those cases, and you can show a logical application of that ratio to the facts you're given, then ultimately whether you conclude yes or no isn't going to determine whether or not you pass or fail the question. So in terms of problem 27, assuming that the investigative panel had the power to impose a penalty of dismissal, it's going to be difficult to sustain any claim that the decision to terminate was one that was so absurd that no sensible person or agency could arrive at the decision, depending, of course, on the nature of the sexual harassment, which you're not told here. I mean, sexual harassment is an expression which covers a spectrum of sins, from conduct which is criminal assault type in nature, inappropriate touching, etc., to persistent requests for a date. Now, if what you've got here is a single request for a date, and which is turned down, and then Mr. James goes about his business, and you've got Ms. Lockworth making a complaint about it, then you might challenge A, whether or not, given the conduct, it was even sexual harassment at all, given that it wasn't persistent, and B, if it was sexual harassment, whether it was of such an egregious kind that it warranted the ultimate remedy or the ultimate option of dismissal rather than perhaps some sort of counselling. So, you've got a range. These are the sorts of range of things you've got to consider in your head. What part of the decision am I looking at and contemplating a challenge to? Why am I saying it's unreasonable? Is is unreasonable because the decision was not one that was open on the evidence? Is it one which was just barely open on the evidence? Is the decision or action taken as a result of those findings one which was open on the evidence, open to the panel? So, for example, if it had no power to dismiss, we wouldn't be talking. We might be talking about Wednesbury unreasonableness on the decision or the fact-finding aspect, but then we might be saying even if the court were to disagree that Wednesbury unreasonableness applied to the fact-finding aspect because it was open, that finding was open, we might then be moving on and saying, well, assuming that's right, the DSSIP acted beyond its power, so that it didn't have a power to dismiss, it simply had a power to make a report to the Director General or the Secretary of the Department, who then had to make, at a separate stage, a decision about what action to take. So when you sit down and you do these sorts of questions in a exam setting, you need to break them down into what parts you're actually reviewing, what grounds you're going to bring to bear in conducting that review, and remember to think back to previous parts of the course about what other grounds might apply, or what are all the grounds which might apply. Now, I said about 15 minutes ago that I might throw in extra fact here, and I sort of did there. Assume for a moment, so some of the varying facts here could be if DSSIP didn't have a power to dismiss, you've got a separate grounds of review. You've potentially got there the acting beyond the power, something that I think we dealt with in week 4 or 5. If you've got facts that 2 of the members of the panel are on a sports team with the complainant, something which wasn't disclosed, you might have ostensible bias. If there's an additional piece of evidence which was weighed in, for example, let's assume for a moment that 2 weeks prior to the making of the sexual harassment complaint, Mr. James had made a complaint against Miss Lockworth for some other matter, and that wasn't taken into account by the investigative panel in reaching its decision on the question of whether or not Ms. Lockworth might have a motive to make a false complaint, then you might also have enlivened grounds of failure to take into account a relevant consideration, and then you've got a whole body of law surrounding what is relevant consideration and what has to be taken into account and what can simply be the subject of comment. You might have the investigative panel bringing to bear on the investigation generalizations or inferences that they've drawn as a result of previous investigations, and then you need to engage with the body of law around whether or not the fair hearing rule requires any of that to actually be put to Mr. James. So what I'm saying there is make sure that when you deal with these types of problem questions, you're drawing on all those other conceivably applicable review grounds for the sake of your answer, your examination answer. Any other questions on problem 27, or do you want to move to problem 28? And who doesn't want to do anything? Okay. Looks like no further questions on problem 27, so we'll move to problem 28. Who wants to... That's right, Ray, don't worry, I'm jet lagged. I got off a plane from Africa yesterday afternoon. I feel like I've been hit by a Mack truck, so we're probably all feeling a bit holiday mode or hot, so bear with me and I'll bear with you. What does anyone want to kick off the discussion on problem 28? Anyone got any thoughts? I'm assuming that everybody's just reading it to themselves at the moment, so when you're ready, somebody can kick us off. Chloe makes a very good point there about the need to keep personal thoughts and accusations out of it. That's the real trick to legal practice and probably to legal study as well when you're dealing with problem questions. Judges, like lecturers, aren't interested in our personal opinions or our half-considered thoughts and stillborn conclusions about different matters. They want to know about what the relevant legal principle is and how those principles, the ratio of these decisions, apply to the facts, and they want to see critical analysis. So that even that critical analysis can become difficult to a part of doing that critical analysis necessarily requires us to bring our personal views often about the factual situations to bear. And you can see that, for example, in problem question 27, the way we were discussing that. But what does everybody think as a starting point? Do you think that Wensbury unreasonableness would apply to this set of facts. When I say Wednesbury unreasonableness, just deal with the decision in Associated Provincial Picture Houses and the ratio in that. Will, if that was all we had to work with, so I want you to move through this in a staged process. If all we had to deal with was Wednesbury unreasonableness, Wednesbury Corporation decision, does Wednesbury or reasonableness have much prospect?
Brett, perhaps I'm sort of wrong in this, but it seems to me that Wednesbury unreasonable doesn't seem to really work for anything much at all, except, say, in the doctor's case, where the Edelstone case, where, you know, it was sort of completely out of proportion and 100% of his income was taken. In these sort of things, it's very difficult to see where it can work at all.
Yeah, look, it's I think that was an observation you made at the outset, and it's a good observation to make. It's one which, without putting it so bluntly, the courts basically try to paint a picture of when they say, as they did, for example, in the Director of Animal Plant and Quarantine, that it's inherently more difficult to impugn a decision on the ground of Wednesbury unreasonableness where it involves fact finding rather than the exercise of a discretion. And it might be, just spitballing here, 1 in 100 cases or so where you're going to have any real prospect of arguing Wednesbury unreasonableness based on the Wednesbury Corporation case. Whether that continues is something we'll see unfold, and that's a result of SZ and the decision in particular of Justice Crennan, sorry, the joint reasons of Justice Crennan and Justice Bell. What you're looking to do, though, I want everybody to get out of their mind necessarily whether or not it's a simple question of whether it will apply or won't apply, but rather let's assume that you're for the plaintiff or the applicant. How are you going to try and make it work? What we want to see is an argument. And when you frame an argument, you don't just in your argument argue one side. A good argument contemplates the difficulties that your case has and then reasons through those difficulties and structures it in such a way as, although a person might have, a judge or an examiner might have started with an idea in their head that no, Wednesbury unreasonableness could not have applied, it will very rarely apply, and so the natural answer is no, it won't work. What they want to see, and the high distinction grades come from, well, the starting point is it's going to be difficult. On these particular facts, it'll be difficult because it is a conclusion open to the decision maker. However, by reason of the decision in SZ, sorry, when I say SZ, everybody, I'm talking about SZ MDS. By reason of the decision therein, there may be an expansive opportunity for it to apply. That is because in judgment of Justice X, this was said. there are close similarities between the facts in this other case and the facts that we've got in this particular problem question, and in the facts of this other case it succeeded. That's the sort of thing that we want to see. It's very easy. I mean, the obvious way to answer problem question 28 is simply to say that Wensbury unreasonableness is a very difficult standard to meet, that it is limited and narrow in its scope and is only concerned with the legality and lawfulness of administrative decisions. It is not concerned with review of the factual correctness of the decisions and not an opportunity to conduct de facto merits review. Under the facts presented, the decision of the DSS not to issue the licence to Gordon was based on concern surrounding child molestation, which was an allegation made in 2005 and formed part of the primary part of the decision made by the DSS. And you've got to remember that when a judge looks at this, they're going to say, okay, well, there are two competing points of public interest here. On the one hand, DSS has got a job to do, and that is to make sure that persons who might, well, one of the jobs they've got to do is the persons who present a risk to children shouldn't be authorised to go and work with children. That runs completely in the face of the protection mandate that DSS has. On the other hand, false allegations are made against people every day. There are people in our community who think nothing of making false allegations against others, and there are those who quite wrongfully and maliciously manipulate the system to cause angst and heartache to other people. Malicious prosecutions are run even by police officers as a matter of course. Some of them really don't care whether or not they've got evidence, they just care based on the often capricious viewpoint they've reached, often even perfunctorily, that a person is guilty, and so they're going to run proceedings. And you know, we would all be fools to think that that wasn't true of other members of the community. So in those sorts of circumstances, making a finding that somebody presents a risk to children on the basis of an allegation, we don't know who made the allegation in this particular case. It's potentially an anonymous allegation, which would be even more troubling, and something, if it were anonymous, or if the facts didn't say, you might even want to point out, well, on the one hand, this could be an allegation made by a former employer who terminated this particular person from working in a preschool because they had witnessed something which was consistent with child molestation. On the other hand, it could be an anonymous complaint from somebody not even identified. Now, relying on an anonymous complaint, which wasn't investigated and which was ultimately closed off with no finding or proceedings brought against Mr. Gordon as a basis for refusing him a licence, would fall into the category, I would think, or the public interest side of, you know, we don't let malicious and false complaints kill people's futures. On the other hand, if it was somebody who came forward and gave their name, were reliable and credible, and they had a direct connection to the protective purpose that DSS were pursuing, then you might say, quite obviously, that's the more prevalent public interest factor that has to be weighed in making a decision about whether Mr. Gordon should get a licence. Now, it's this tug of war between these approaches which guide the decision making, and which are the grey area that you guys, both as students and potentially as practitioners, have to be able to grapple with. And that's what we want to see in these questions. So on the one side, you might say, on these particular facts, the decision of the DSS not to issue a social support workers licence was based on a police investigation of child molestation a relevant and obviously relevant consideration, and that being the basis of the DSS decision, it was within its power to arrive at the conclusion that it did and to reach the decision that he should not receive a license, and that it could not be said that the decision they reached was so absurd that no sensible person could have arrived at it. On the flip side, you might want to say, if the facts were that it was an anonymous complaint, one which was categorically dismissed. So police triage complaints. They obviously don't have the resources to investigate every single complaint. A lot of matters which are raised with police are frustrating nonsense, stuff that you would expect your average school child to be able to resolve, sort of neighbour dispute type stuff. When they rock up at those sorts of things, they don't always make a complete investigation of the situation. They might give each side some sensible advice about trying to live harmoniously in the community and not distracting the police from pursuing important criminal allegations, and then they might move on. So if that were the nature of an investigation, you wouldn't expect it to weigh heavily into an administrative decision, because it's not really one which is reliable in any sense. It hasn't been properly investigated. And similar might be said of an anonymous complaint made against a person. If somebody just rang up a police station and said, I've got information that X is a child abuser, and hangs up the phone, what you might expect the police to do with that, I would think, is very different, and the extent to which a government or administrative decision maker could rely upon that in making a decision that would affect a person's future would be very different to the other category of case that I mentioned, which might be where an employer or a person employs them in a childcare centre, sees something consistent with child abuse, and makes a report or disclosure, as you have to, for example, in the case of childcare centres, to the state agencies responsible, usually the Departments of Community Service or Family Services, depending on how they're called in different states. And that would be very different. And you'll learn a decision in ethics when you come to it called ZEANS, and this applies to not only professional conduct of lawyers, but also to disciplinary proceedings generally, which is that a person might be convicted of an offence, but it's not the fact of a conviction which is the relevant consideration. What is the relevant consideration is whether or not the conduct still operates. So just because somebody has got let's assume for a moment a person seeking admission as a lawyer, the fact that they might have a conviction for possession, even supply of drugs, some years prior, isn't going to necessarily make them a person who's not of fit and proper character, because the test for whether or not a person is fit and proper to be a lawyer is one which is concerned primarily with their honesty and trustworthiness. So what the decision of ZEANS, it's a High Court case you'll come to in professional conduct, talks about is looking at the content, not simply the conviction or the allegation. And these are the sorts of arguments that you want to be able to raise in the context of whether or not Wednesbury unreasonableness might not apply, because if you then bring in SZ into the fray and you pick up on the choice phrases, and in particular have in mind, as I've said, the decision, joint reasons of joint judgment of Justice Bell and Justice Crennan, you might be able to mount a more expansive application of unreasonableness, and you might be able to persuade the reader of your argument, be it an examiner or a judge, that this is one of those cases that does fall just barely on the right side of the line, such that you get up on unreasonableness. And as Ray says, it can always seem, and this is always the case in law, at first blush, a case might seem hopeless, and it's only after you work it through and you think through all the arguments that you really are in a position to provide thorough advice and to argue the merits of it. And I can tell you, as a practitioner now of as both a member of the bar and as a solicitor, I have run cases where I have said to the client, I don't think this has any prospect of success. I think you're wasting your money. I think you're going to lose, and I'm telling you that at the outset, and then they end up winning. So, you know, hopeless cases can seem hopeless and turn out not to be, and it's only through that process of actually preparing them and arguing them that you are able to decide. So that might all be a fairly long way of explaining that when it comes to an exam question like this, identify where the gaps are, and in fact you might even be asked in the exam question to identify any further pieces of evidence that you might need to be able to identify, to be able to properly argue the case, and construct or frame your argument around that. Don't get too carried away with whether or not the answer is yes, it applies, or no, it doesn't apply. What we want to see you doing is grappling with the cases, the principles, the ratio, and applying them to the facts, and presenting a cogent, considered, principled argument, written argument. All right. Any questions on problem 28? Looks like we've had a few questions in the time I've been discussing. Let me have a quick look. So you're all, Jimmy, Murray, Joel and Kylie, Paul, you're all making interesting observations there. It sort of follows on from what I was saying a bit earlier. Draw on some of your other grounds. So problem 28, if it were an exam question, enlivens obvious failure to comply with the fair hearing rule, I would think, in that it doesn't appear that the previous complaint was ever raised with Gordon, so that the Department of Community Services never actually gave him an opportunity to be heard. So where you might not succeed on Wednesbury unreasonableness, you might have some other grounds, and the exam questions I write tend not to just test one area. I'm not interested in, it won't be a case of just deal with Wednesbury unreasonableness on this particular question. What we're looking at is your ability to look at a problem question, know what your tools are, identify what the tools that apply to any particular question are, and then to be able to go in and argue them in the way I've been discussing for the last sort of 5 or 10 minutes. Anything else? Has anybody got a question I haven't answered? Or John asked whether the exam questions are based on the whole term or the last few weeks. They're based on the whole term. As you might not have joined us, Jolan, but I said there'll be 3 questions. You'll have to answer 2. At least 2 of the 3 will be problem questions, and 1 of them will be an essay. You decide which ones you want to do, but problem questions, whilst they might have in mind grounds that we've dealt with in specific weeks, or they might apply more predominantly than others, they won't be exclusively tested. So you need to it'll be, as I said, the whole term, not just the last few weeks. But I think the fact that I've told you they're problem questions means that whilst you need to, for example, have a strong understanding in your head of weeks 1 through 1, 2, 3, and sort of parts of 4, in order to even understand what it is that we're doing in this subject by week 9, I won't be looking for penetrating analysis of weeks 2 and 3. I want to be able to establish, for purposes of answering problem questions, how the content from weeks 2 and 3 apply to the practice of administrative law. 3 hours, I think it is 3 hours. The time for the exam is decided by the school. I don't know offhand whether it's 2 or 3 hours, but I can tell you that it is. You have to answer 2 questions. Colin says he thinks it's 3 hours. That might be right. You'll need just consult the school on that. They'll know. We as lecturers don't get involved in deciding that, and I don't anyway, because I'm assisting just with term 3, terms 1 to 2 of administrative law are taught by Dr. Olsen. And I'd say we'd be keeping it consistent with the last 2. Does anyone have any questions about Wensbury unreasonableness?
I've got a question, Brett.
Yep.
I found a case where, it was Mr. Fraser, I think I put it in one of the assessment areas, where he was a veteran who basically had skin cancer and was being treated for that at the time when he was discharged from the army, and they discharged him as medically fit. I mean, at the time he was having chemotherapy, he had a gammy arm and a gammy back and that sort of thing. But basically I would have thought that that's unreasonableness, because I don't think a reasonable person would be able to release him as fit or medically fit when he had that at the time. But would it be better to argue irrelevant considerations, or not taking the relevant considerations into account, rather than unreasonableness?
Look, it's possible. I would have to have, one of the thing about those sorts of cases, Ray, is that employment law, as I think I said a couple of weeks ago, is technically an administrative legal process in the sense that there's a tribunal that determines the fairness, but it's not just an administrative system, because it is concerned with dismissal in the private sector as well. Military discharges presumably have their own system again, that is one on top of the Fair Work Commission processes. I'd have to have a look at the details of how it worked to probably answer your question more closely, and you would also need to have a look at the statute which applied. So what we'd be looking for is a provision within the statute that tells us, and they tend to have it. It's true of both military and paramilitary organisations such as police forces, when a person can be discharged as medically ill, and then there are guidelines as well. So we'd be, as a starting point, I would think there's nothing particularly unreasonable about discharging a person as medically fit whose back isn't working, whose limbs aren't working properly because they're going to have difficulty performing their role. But then there may be guidelines on top of that that say, and rehabilitation is the starting point. What they often do in police forces, which are more civilian, sort of halfway to the civilian workforce, if you like, is that they look for alternative jobs, so redeployment options. But again, this is a very complex area because it's industrial more than it's administrative. I'm not sure if I've answered your question. I think you were sort of looking at it more from the administrative law issues, but I don't want you guys to get, I guess the short answer, Ray, is don't get too bogged down in the industrial law cases because they're more complex than they need to be, albeit there's administrative flavour to them. Administrative law, albeit at the low end of the range, is not particularly complex. It can be very technical, and I don't know that it's going to be instructive for you guys to get too bogged down in that detail. Past pay, Jolyn asks whether past papers will be useful. Past papers are always useful, if only just to practice the skill set. I don't want anybody thinking that the current exams will look exactly like past exams. There tends to be a degree of consistency in the way that we put them together, but we don't repeat them. So I don't want you thinking that short form preparation will be just to do some past papers. You'll need to grapple with the content of each week, but certainly I would suggest that you do some past papers. The past papers, I think, should be available through the school. If you can't get them from the school contact, send me an email, see what I can find out about it. I don't know because I'm just helping out this semester, so I'm not sure what the past situation has been, but I would imagine that CQU is exactly like any other university, which is that they make them available through the school. I will be providing, John asks whether or not we'll be getting more exam advice. I will be providing you with more exam advice. There are no problem questions in the next 2 weeks of lectures, but in the exam prep week, I am proposing at the moment to hold 2 tutorial sessions just to go through exam preparation. I won't be giving everybody the answers to the exam questions. You won't be surprised to learn, but I will be on the 27th of January and the 30th of January holding one of these type of forums just for people to ask questions or for us to go through, for example, problem questions or similar sorts of problem questions. But if you've been doing the problem questions up until this week, that'll be a very solid start. Anything else, anybody? All right, Annette, And everybody else, if there's nothing left, we'll call it a night. We seem to consistently go over the hour allotment, but it's probably better for you than undercooking the goose to give a bit more time. So, as I said, I'll be trying to resolve this issue with the lectures. I'm not sure why. Apparently both of them are playing at the same time when you open them, but I'm onto it. I've just got back from 2 weeks away, so I was out of the country and couldn't fix it for you previously, so I'm working on it at the moment. Alright everybody, talk to you next week. Next week's lecture, so let me have a quick look. I'll just confirm for you because they're a little bit varied. Wednesday the 14th at same time as this week, 6 p.m. Sydney time. So that's 5 o'clock your time. 5 p.m. Queensland time, Wednesday next week. Yeah. All right, folks. Enjoy the weekend. See you next week.